The following script was written, verified, and approved by compliance professionals at financial regulation courses. FINRA Rule 3241, effective February 15, 2021, addresses critical conflicts of interest when registered persons are named beneficiaries or hold positions of trust for customers. Adopted through Regulatory Notice 20-38, it responds directly to patterns of financial exploitation of senior investors by those in positions of trust. This rule creates a uniform national standard, ensuring professional boundaries aren't crossed when clients grant personal financial authority to their representatives. It fills a critical gap, operating alongside Rule 2165's temporary hold authority and Rule 4512's trusted contact person requirements. The rule applies to any person registered with a FINRA member firm. Crucially, the definition of customer is broad and deliberate. It includes anyone assigned to a representative within a 6-month look-back period, specifically preventing evasion via account transfers after a resignation. Registered persons must provide prior written notice and receive firm approval before assuming any trust position or accepting bequests from estates. If joining a new firm with existing designations, notification is required within 30 days of the account being assigned to the new representative. Member firms must evaluate these arrangements for undue influence, customer vulnerability, or conflicts that cannot be adequately managed by the firm. Rule 3241 identifies 2 categories: being named a beneficiary of an estate and holding positions like executor, trustee, or attorney-in-fact. Operational compliance dictates that even approved trust positions must not result in financial gain beyond reasonable and customary market fees. Registered persons cannot steer assets into investments that generate personal commissions, fees, or any other indirect financial benefit for themselves. The rule permits an immediate family exemption, covering parents, grandparents, spouses, and dependents for whom the person is materially responsible. However, all non-family designations require a formal written determination from the firm. This may include approval, approval with conditions, or outright disapproval. Firm disapproval is binding, serving as an independent check whose authority cannot be circumvented by mutual agreement between representative and customer. Firms must integrate Rule 3241 into their written supervisory procedures, addressing notice forms, review timelines, and specific escalation protocols for high-risk cases. Ongoing monitoring is essential to identify developments warranting reconsideration, ensuring that approved arrangements remain in the best interest of the customer. FINRA's 2026 Oversight Report highlights that supervisory systems must actively identify circumvention tactics, such as naming a representative's spouse as a beneficiary. Regulatory Notice 26-02 reinforces that senior investor protection remains a priority, with focus on detecting indirect exploitation and direct rule violations. In summary, Rule 3241 mandates full disclosure and firm approval for all non-family beneficiary or trust designations. Remember the 6-month look-back on customer definitions and the strict prohibition on extracting financial gain beyond customary market rates. Effective supervision and strict adherence to the notice sequence ensure the advisory relationship remains professional and free from the inherent conflicts of inheritance.